Yeah, I did. But that was
Boy, Dad can really plan these things, can't he?
What about your,
Council holds periodically where we bring people in and we do some subject matter of our own with our own people. We thought that last year, you may recall, we had a separate program as part of Law Day, which was not part of the town hall meeting, but we're going to institutionalize it. And so we're taking at least this one under the town hall meeting setup. Our first speaker today, our first guest today, is of course Woody Berge, who I guess name is synonymous. I don't guess, I know. His name is synonymous with the real estate directorate. Woody was the first civilian director of real estate, but more important, even before he was a director of real estate, as he discussed last year, he really was the guy that created and was the life and blood and the vitality that went into making the Corps of Engineers the great real estate agency it is. That portion of the work that's so vital to all of our projects, both in the military and civil side. Woody will take the first 45 minutes today, and he'll be talking about, again, recapping, I guess, the very beginnings, and then going into, well, whatever kind of time it takes him, whatever period of time he covers, that's fine. I hope he doesn't do everything because I want to bring him back again after this. So, having said that, let me not waste any more time. Let's bring on Woody Berge.
Mm-hmm. Mm-hmm. Can you hear now? Okay. Les, I want to thank you for inviting me to participate in this Law Day. Your theme, We the People, is very appropriate, I think, in celebrating the bicentennial of the Constitution. As we all know, we live in an open society. People are entitled to be treated fairly.
Microphone?
Yeah, you put it on. Can you hear it?
No, that's just for them, I think. Let me see if I can get the mic set up.
Okay.
Go ahead.
And these rights, dignity to be heard, are certainly applicable to the real estate operation of the Corps, and within the parameters of our legal system, and which says all people must be paid just compensation. Reminiscing a little bit, opening comment, real estate is a tough thing to operate under and be a part of. You've got to have sound real estate policies and procedures. You've got a lot of laws, acts of Congress, court decisions to follow. And a lot of it, in my opinion, is good old sound judgment on how to deal with the public. By its very nature, real estate, again, is a tough thing because the government wants something from the individual, and of course the individual wants something from the government. So you have to equate fair treatment to the individual landowner, individual members of the public, and at the same time protect the interests of the government. Can you hear me out there? I'm going to go back, for those who weren't here last year, and give you a little genesis of how the real estate operation really started. And when I say that, I realize the old War Department was handling real estate back in the 1800s even, but the real estate operation of the Army, then War Department, started in World War II. It was a hectic time. Prior to Pearl Harbor, the real estate operation of the military was under the Quartermaster General, and construction was under the Quartermaster General. And as you know, The Corps handled civil works construction and real estate to the extent that there wasn't a large program back in the 30s, and I wasn't around those days. But to give you a little background and lead up to the main things I want to say, the War Department went through hectic times in the 40s, 41s, for the simple reason that the military buildup was going in high gear, and frankly, the War Department at that time just was not geared up from the standpoint of procedures, people, and many other elements to handle the program. In February of 41, the Secretary of War brought over a guy named Jack O'Brien, who was the Deputy Assistant Attorney General, to head up the new and expanding program. O'Brien brought 3 of us over from the Justice Department with him. We had a nucleus of about 35 people. And in the meantime, at that time, early 41, late 40s, I cannot describe to you how much real estate had to be acquired and in demand. As you know, the build-up, this was about a year before Pearl Harbor, but the War Department was building up fast. Ordnance plants, airfields, training areas, and no people to do the job. So this was the environment that we started with. We did some crazy things, really. We had to. The first thing, there were no policies and procedures, and when I say none, very few as we know them today. So we had to roll up our sleeves, and in the meantime, get people on board. I think at the peak of the war, the real estate organization had roughly 500-600 people, plus thousands of people out in the field. But we had to do a lot of things. We had to beef up our appraisal staff. Basically, we went to contract appraisers. We had to refine the mapping procedures. We had to get into the title evidence. In those days, this better? Can you hear me better now? In those days, not being too technical, the War Department used abstracts of title. Well, an abstract of title, a lawyer has to examine the abstract and come up with an opinion. We didn't have time for that, so we went and established a procedure of title certificates and title policies, the same as the real estate organization has today. We had to develop many lease forms, many forms to operate. For example, leases. We had to revise the lease form, have make provisions for automatic renewals. When we got to in the early 40s, you had to renew a lease every year under the then War Department procedures. We had to develop navigation easements. At the end of runways that were being built, to take easements so that when the planes went off the runway, there was no allegations of a taking. So we had to get a real estate interest. We developed a cemetery relocation policy, which, in my recollection, we had never had. We had to do a lot of innovative things with the Department of Justice. And I must say to you that in those days, we were acquiring hundreds of thousands of acres of land overnight, and I mean overnight. Letterkenny Ordnance Plant up in Pennsylvania, we got an order at 6 o'clock one night. We had to have possession of the 20,000 acres by the next noon. That type of thing. So we did a lot of innovative things. We didn't have time to go through the paperwork, and basically everything was through condemnation so the Army could War Department could have possession of the land. Condemnation, as many of you know, to institute a condemnation proceedings through the Attorney General, the Secretary of Army now has to sign a request to the Attorney General to condemn land with the state to be acquired, description of land maps, and those types of things. we didn't have time to get signatures on paper, so we just called the Department of Justice. They'd call the United States Attorney, and 24 hours the condemnation suit was filed. And people asked me, well, what about the paperwork? I said, the reaction was, oh, we did that later when we got time. We'd backdate letters that the Secretary signed to the Attorney General. A lot of things that people today would just faint at. We did some crazy things, for example. We literally sent in trucks after we'd filed a condemnation suit and moved people off the land. We would pile up their furniture in trucks, hundreds of trucks, and move them out, and tried to help them to find substitute temporary places to live. It was rough, and again, that was a type of thing we wouldn't think of doing today because of some things that some of you know and others don't. And I'll refer to it in a minute. We even went to the point where we had a young major take over a big office building in Seattle by a condemnation suit, and the judge held him in contempt because he was ordered by headquarters here to evacuate tenants, kick them out, and he was enjoined from doing so by a federal district judge. Well, the answer to that was simple. We just sent him to Mexico for a couple weeks. He needed a vacation, and so he was without away from the jurisdiction of the judge, and the judge wanted to put him in jail. Well, that was no big problem for us at the time. But one of the things that the procedures and policies that we established are really today is an offshoot of what we did then. Sure, there have been a lot of refinements, there have been changing laws, there have been changing policies, but a lot of the forms and procedures that we established 45, 47 years ago are still in effect today. But as I say, they've been refined. We learned a lot of things, and a lot of things have been learned since World War II up to the present time. And it points up in my mind, and I think the Corps has it, there were no emergency contingency plans to handle construction, if you will, none for real estate. So we were in a strange new field and having to abuse people, having to take an awful lot of shortcuts, and but we came out all right. And I think that the things we did in World War II were good. Some of them, as I said, we would absolutely not condone that, or the public wouldn't today. Well, we had thousands and thousands of ownerships we acquired. As you can well imagine, at the start of World War II, the Civil Works program, which was never very large in the 30s, it completely dried up. And I must add at this point that some of you know that the Quartermaster Corps, the real estate and construction, those functions were transferred to the Corps of Engineers in December of 41. As a matter of fact, a couple of days after Pearl Harbor. So there we started. We acquired the land. It took a long time to clean up, but in the meantime, after the war, when the military program went down, big upheaval during the war, as you well know, the Civil Works programs were coming in line. And so we were disposing of many of the military properties we had acquired, but at the same time having to grapple with the terrific Civil Works program, which I would say was just as, over a period of years, which was just as voluminous as the military was during World War II, but not in such a concentrated time frame. Now I want to go into one of the key problems of the Corps, and this is relates to the just compensation payment under the Constitution. During the war, we would appraise each property one time. We'd make an offer to the landowner, and if you didn't take it, we condemned. And so you can imagine during those periods of time, so many people wound up in condemnation. The reason was we could not wait. We needed possession. So that was the start of a series of events and a series of disagreements in connection with how do we compensate landowners within parameters of the law and just compensation. Well, we went along for a long time on what we call the one price policy. It was criticized. Over the years, we changed. So we decided, well, okay, we'll get 2 appraisals and offer the highest of the 2. That helps some from the standpoint of the public and the Congress. Then, because of a kind of a meager language in a appropriation bill for the Civil Works, it was by the Congress for the Civil Works appropriation, the Congress said you should negotiate. And we interpreted that literally. And so we went to still the 2 appraisal policy, but we would offer and could offer under our policies values under the higher of the 2 appraisals. This started really so much controversy before the Congress, as Les knows, because he was up in the Hill in those days. And we defended our policy, rightfully or wrongfully. I had briefed, remember, we were offering under the appraisal on the theory that the courts had said, and the Congress in our interpretation had said, just compensation is arrived at by negotiations, and that an appraisal is not it's just an opinion of value. A lot of people thought appraisal comes along, that is the value, and of course that's not true. But in any event, this started a chain reaction, and the Congress got into the business of investigating our policies, leading up to the 1970 Act, which I'll refer to in a minute. It was called the Real Property Acquisition and Relocation Act, I'm practically right, January 2, 1971. Unfortunately, I was designated as the Defense Department witness for how long that go, Les? 7 or 8 years. We testified year after year, basically on how we treat landowners. Now, the Army, we in the Army and the Corps of Engineers, we knew that landowners were being hurt to the extent that all we could basically pay was what is the fair market value of the land, i.e. just compensation based on appraisals or negotiations. But in those days, up until 71, there were no provisions for paying some of the damages that landowners suffered, and we knew that, like moving costs, loss of business, those types of damages which the courts had traditionally held were consequential and not payable legally as part of the acquisition division, part of the acquisition process. But in any event, this started the hearings before the Public Works Committees, and mainly in the House, I guess, Les. We had some hearings in the Senate side, I think. But and with a lot of justification, the Congress said, in effect, something has got to be done to treat landowners more fairly. We had disagreements. Sure, we had disagreements. The executive side of the government and members of the committees. Some of the disagreements, some of the things we wanted done or opposition were probably, many of them were subject to disagreements. We didn't always agree with the committees, but the whole thrust was to what does the United States do to treat landowners fairly when their property is acquired for public work purposes. The committee hearings were lengthy, as I said, controversial. We went through, as I said, 7 or 8 years of hearings, and disagreements came up like this. Several members of the committee, as I recall, insisted that we, the Corps of Engineers, should furnish each landowner a copy of the appraisal. You can argue for that, you can argue against it. We thought very strongly that should not be done. And this was a good illustration of a definite dispute we had with the committees. I remember one day, I don't know whether Les was there, I really took a real beating from some congressman from Iowa. And he was insistent that the law was going to read that everybody gets a copy of our appraisal, and of course I testified and took the beating. It wasn't, and we had reasons for it. If you give a landowner a copy of your appraisal, which lists the buildings and all this type of thing, the guy is going to say, hey, you didn't include the outhouse in here, and you know, you get into a lot of disagreements as to did you appraise this and how much, and just nitpick your whole value, whereas an appraisal is basically the overall value. You don't just appraise the outhouse and the buildings. They contribute some value, of course. Also, a very cogent reason from our standpoint, supported by justice, that each time you negotiated with a landowner, it was a potential litigation on behalf of the United States, i.e. a condemnation proceeding. And the theory, right or wrong, was that the United States government, maybe a tough theory, should not give away your evidence. But in any event, one element of the Act on January 2, 1971, which is good legislation, was that they took care of that negotiating controversy. The Act reads in effect that the Secretary of a Department, and this applied to all government agencies incidentally, they wanted consistency, which was good. You couldn't argue against that. But the effect of it was that the head of each department would fix a value that he thought represented just compensation and make that offer to the owner, but with the condition that the offer would not be less than the approved appraised value, which took care of the Corps of Engineers policies, and it was dictated, and we really didn't object to it. But now it's legislation. On the release of appraisals, the Congress said in the bill, you will give the landowner a statement of and the basis for establishing the just compensation that you offer to the landowner, which was fair. And this was really in lieu of offering the appraisal. I guess we compromised, you'd say. But now the Corps has an elaborate system to provide for a letter to each landowner, which obviously describes the land, the estate the government wants to acquire, how the appraisal was arrived at, a listing of the buildings, a listing of the appraisal approach, income, cost, comparable sales, and a very comprehensive statement for the benefit of the landowner to see how the value was arrived at. It's good legislation, and it settled a very controversial issue with us. And now the other part of the January 271 Act, and the Congress took care of this, we really had no great objection to this, what I'm going to relate to you, for the simple reason that in fairness to all the chiefs of engineers, the executive part of the government, and I'm referring to other agencies, Certainly in the Corps of Engineers, we knew that people were being hurt. We knew that, but we had, in our viewpoint, and I think everybody agrees with this, we had no legislative authority to pay these types of things. So in Title II of the Act, it provides for what I'll refer to as relocation assistance. We obviously pay the landowner and offer him the price within the parameters that I just referred to. But over and above just compensation, the Congress said, and I'm not going to quote the act, it's rather lengthy, but it had several provisions which does help landowners, and I think now the government has a good system. First of all, it authorized moving costs, which we really never had any authority to do. A landowner, owner of a house can be paid moving costs up to $500. It's got a ceiling on it. And owner of a business can be paid moving costs. But also I meant to say the dweller, he can receive moving costs or a lump sum payment. And the same for a businessman. He can receive moving costs, or he can elect to get a business loss. It's a formula in the Act where you examine his net income under the procedures we've established in the law, and he can get $2,500, not less than $2,500, more than $10,000. And I should inject in here, and there's a couple more provisions in the Act I want to refer to. I should inject in here, however, the law, unless I haven't had a chance to read it. You told me a few weeks ago it was on your desk. The law has been amended in certain ways, and Jerry Lease told me in real estate, told me some time ago, some of the figures I think, Jerry, are changed, but is that correct?
Yes, it's law now.
It is?
Not effective for 2 years.
Oh, it isn't? Well, when I'm saying these things, I'll go back now to what the original law said, but I want to make it clear. I haven't read the new law. Also, a very important factor over and above just compensation was that a landowner cannot be moved until safe, decent, standard housing are available to him as determined by the government agency acquiring the land. And he is entitled to a differential with some details which I won't go into. He can receive up to $15,000. Make it very simple. If we paid $10,000 for his house, he can receive up to $25,000, i.e. a difference of $15,000. We also pay him under the Act closing costs on his new house and some of the expenses that he has to pay. Now, this has been I wanted to mention this, and I didn't go into any detail last year. Many of the people in real estate and Les are very familiar with it. But this is one of the types of things that I mentioned was an evolutionary thing from back in World War II, where we had the so-called one-price policy, and where we are today. And it's a good law. People are treated much more fairly, in our opinion. And I want to emphasize that all during the hearings, and we in the real estate game, including the chiefs of engineers and the secretary, recognized that we had a tough problem because we didn't have authority to pay some of the things that hurt landowners. And this law, I think, is now good, and I hope it's refined, and I'll have to check with Jerry at least one of these days and see what it is. Jerry, it doesn't take effect for 2 years, is that right?
Yes, unless the lead agency pull it together earlier.
I see. Okay. Now another subject which was very controversial that I wanted to highlight in the time I have here. I mentioned that after World War II, the civil works projects authorizations for rivers and harbors, flood control, dams and reservoirs came into the system. And as I mentioned, civil works programs almost completely stopped during World War II. We had, of course, some cleanup work, but Congress dried up the funds and we concentrated on military. I mentioned also that after World War II, the avalanche of civil works projects came into being for, I guess, up until about 10 years before you haven't had an authorization bill in a long time. Well, I guess you have one now. But the civil works program was a fantastic thing, in my opinion, just as fraught with problems and volume as the military during World War II. After the war, on civil works projects, and let me confine it mainly to dam and reservoirs, and you all know the Corps has several hundred in place. There was no policy of how much land to acquire for a civil works project. Now you have some revetment projects and that type of thing, but our main concern over the years, which I'll relate to you, was how much land you take for a big dam and reservoir project. There was no policy. We started out on the premise of taking fee title to the whole reservoir. Obviously the dam site, the construction area, and all the land needed for the project design flood, plus a blocked out taking line, which means nothing more, the highest flood that would come along under the design. Go clear up in the upper reaches and on the sides of the river. We took absolute fee title. There were some few exceptions where we would take a flowage easement. And a flowage easement is nothing more than giving the government the right to flood the land on occasion, prohibit human habitation, but the landowner reserves the right to farm it and that type of thing, but always subject to the government's right to flood the land. There was a hue and cry that the Corps was taking too much land for civil works projects. As I said, there was really no published policy at the time. So it so happened that we, for the Bend Brook Reservoir outside of Fort Worth, we acquired a large property, 1,500 acres, owned by a man by the name of Sid Richardson. And Richardson was a very wealthy and prominent man in Texas. About 600 acres of his land was above the conservation pool. Let's say half of it was in the conservation pool, which means it would be flooded permanently. Another 600 acres was within the flood control pool. And Richardson, of course, would not agree to sell all the land. He wanted the right to use his property down to the conservation pool. The public would not be permitted on the land, which was absolutely diametrically against our policy. So we condemned, and Richardson in court contended the Secretary of the Army had no authority to acquire the land above the conservation pool. As I recall, the Federal District Court upheld us. Circuit Court reversed, and it did go to the Supreme Court, and it was decided that we did have the authority. But in the meantime, a change of policy was obviously imminent, and we knew this. And most of what I'm saying is in the hearings of the Congress about a change of policy. Mr. Richardson went to the president, who happened to be President Eisenhower at the time, and complained bitterly that the Army was taking too much land, not only of his own property, but other parts of the reservoir. So then there was a and the president inquired about it. General Robinson, who was then the deputy chief of engineers, and Woody Berge were called up to the Bureau of the Budget at that time. And Roland Hughes, who was then the director of Bureau of the Budget, told us that the president said wants the Army to revise its policy in some way, no specifics, but to take less land, and don't take all the title to this land. And in the meantime, there were other viewpoints from Congress and landowners, but so as a result, the Interior Department and the Army negotiated a land acquisition policy, which was famously called the 1953 policy, which greatly reduced not the amount of land, but the interest in land that we would acquire. And it came out as a joint policy. The gist of the policy is we would continue to acquire fee title to the construction area, dam site, of course, and we would acquire fee title only to the conservation pool, plus a 300-foot horizontal line, horizontal from the edge of the conservation pool. It had an exception in there in the policy that if in precipitous country or flat country, we could acquire above the conservation pool to the 5-year flood line. We deliberately chose to apply and to acquire only fee 5 years, which is flooded on the average of once in 5 years above the conservation pool. And above the fee taking line, a good share of the area of a big reservoir, we had only flowage easements, i.e. the right to flood the land, with some restrictions in it. And the Congress didn't like our flowage easements either. But in any event, we did not have public hearings when that change was made. It was published. We did not have public hearings, and I honestly don't remember why, but we, in effect, were told to change the policy. Well, you can well imagine what happened, because when you take such a limited amount of title, it restricts the use of the public to the waters of the reservoir. A 1944 Flood Control Act by law mandates that the waters of any reservoir shall have adequate ingress and egress for all recreational purposes. And this brought up another problem for us. But the point is that with such a large area of flowage easements, there was not enough land, and it's come to pass, we know that now, for the development of recreational opportunities. This brought up a legal problem right away. When we adopted the policy, we started to acquire some access areas, not being authorized to acquire recreational areas. So we would acquire some land near the conservation pool, fee title, take title to it. And so we got into a lot of court arguments over that, because landowners said, well, you don't have any authority to acquire land for recreation. All you have the authority to do is to build a road through the easement area down to the water. Well, obviously, under that circumstance, people come down at the water on a Saturday or Sunday. They got to park. You got to have latrines and this type of thing. So they bring their lunches. So we did acquire access areas under the 44 Act, and we were upheld in the courts on that. But it's come to pass that the 53 policy has not provided in certain reservoirs nearly enough land for recreation. And well, in '57, we went along with that policy for 2 or 3 years. In '57, the Government Operations Committees held extensive hearings, and the environmental groups, recreation groups, were very vocal in saying that the Army does not have enough land for recreation, fish and wildlife, and those types of ancillary things that go with a water-oriented project. So there were extensive hearings held in '57 before the Government Operations Committees. And I might add that back in '53, the Secretary of the Army and the Chief of Engineers were not enchanted with the '53 policy. There's many reams of letters where the Corps was jockeying to get more land, but yet comply in effect with with the edicts of the President and other factors. But but because of the pressure, because of the public hearings, another policy was adopted. I always refer to it as the Kennedy policy, but it was brought about by the committee of the Congress and these groups I mentioned, environmentalists, recreationists, that we should go back to basically the pre-1953 policy, and that was adopted in 1962. And so we went back to a policy which stated the whole reservoir above the conservation pool, of course, construction area, dam site, clear up in the upper reaches would be acquired in fee title. We chose to, with some exception of policy, we chose to make an interpretation. We would acquire fee title to the reservoir, clear up to the full pool, but in the upper limits of the reservoir, above the conservation pool, if land was not required for recreation, fish and wildlife, we could acquire flowage easement. Matter of fact, I think that was in the policy, but we had criticism because of some of our decisions that, hey, you should acquire the whole thing in fee title. But so the history of the civil works projects is long. It was a tough number of years we struggled through, but I think the policy is now well accepted. I don't think there's, to my knowledge, no eminent changes to be made in it. But these, I'm just trying to give you a couple illustrations as to how some of these policies evolved. We had a lot of legal problems fraught with operational problems, Air Force programs, which we still have. So we had a lot of fun. But again, I think I should emphasize a lot of the things that went on World War II are now the foundation of policies today. And Les, I want to end in about 1 minute.
Sure.
We in the real estate business over the years had a lot of fun. It was exciting. We had a lot of frustrations, but thank God we worked for the Corps of Engineers. All the chiefs of engineers and the whole hierarchy is just a super outfit to work for. As you've heard many times, the integrity of the Corps is never questioned. And that is why it was a privilege for me to work for the organization.
I think you can all recognize the enormity of events that occurred in the period of time that Woody was the director. That it's impossible to cover more than 1 or 2 or 3 major things
I should say so.
in 45 minutes or an hour and a half or maybe even 5 hours.
I could go on for hours.
Yeah. You know, if you just stop and think about it, and you take the 8 years that Woody was involved in the issue of relocation cost, and the enormity of that issue, the social factors that were involved in that, of the uprooting of communities in the urban and rural areas, and the time he spent on that, and the results, it's just a tremendous amount of knowledge that we have in some people like Woody, and we really have to do everything we can to hold on to it and bring them back more and more often.
Thank you, Les.
Our next guest is, I guess that's a funny word to use when I talk about Manning. Oh, we are?
Yeah.
Gonna take a break for a few seconds?
Take a break for 5 minutes and come back.
Okay, we're gonna take a break for 5 minutes, and then we're gonna return with Manning Seltzer. Please, come back.
All right.